All right, good afternoon, everybody. We'll go ahead and get this webinar started. Hope everyone fared okay with the storms yesterday. So what we're going to do today is go over the upcoming form changes that will take effect on September 12th. Wherever you currently get your forms is where those will be available on September 12th. There will be no action needed on your end. We will be coordinating with all the forms vendors directly. We're not going to be able to take any questions today due to the volume of people on the call, but certainly the legal staff and myself will be available between now and the form changes, and certainly thereafter if you have any questions. So if you have any of those, please feel free to reach out to the legal staff. Like I said, we're not going to be able to take any questions today. So any question, anything, the chat or Q&A should simply be used for any sort of technical difficulties. So we're going to go over these forms in order of form number. Some of the changes are more substantial than others, but we certainly will try to get through this as thoroughly but as briskly as possible. So the first change is to the listing agreement, Form 220. This is probably the most minor as far as syntax changes that we have. And that is on paragraph 13. So that is currently where you have the option of, are we going to publicly market the property or not? This is sort of the clear cooperation section. And what that has is now, if you're going to publicly market the property, which is option 1, that is the option that requires the property be listed in the MLS. You're now going to put in there which MLS services the property is being entered into. That way, the seller has more knowledge of where exactly you're going to be listing this property. If it's going to be in multiple MLSs or if it's just going to be in one, you're going to list that out there. So that is the only change that is being made to the listing agreement, but did want to bring that to your attention that change is being made. The next change is to the conditional release from listing agreement, as well as for the conditional release from buyer agency agreement. So these are the forms that can be used in order to release a buyer or client or a seller client. There's been a couple of cases in front of the Real Estate Commission this year in which individuals, associated licensees, prior to leaving a brokerage, went ahead and signed these agreements on behalf of the brokerage, releasing clients they were working with, and then would take those clients with them when they went to the new brokerage. In all of these cases, the commission found that to be in violation of license law, and to avoid any confusion on that, the forms committee wanted to do the following changes. So now there's going to be a disclaimer at the top, letting you know that this form should only be signed by the broker in charge and should be signed by the broker in charge, can only be signed by the associated licensee with written authorization from the broker in charge. So the default is this is going to be signed by the broker in charge, unless you have something in writing or office policy in which the broker in charge allows associated licensees to sign this form. The hotline would not recommend that as the course of action. Since the clients belong to the brokerage, this is a form that should be signed by the broker in charge. To signify that the client belongs to the brokerage, all the terms here, broker, have been changed to brokerage. The reimbursement of costs, we made clear that those reimbursements are payable to the brokerage. They're not payable to the individual licensee. And then instead of having a broker line at the bottom, it now says broker in charge. That should also be helpful if you're using form software, because you will not have it auto-populate your broker signature from other forms in there. So be mindful that these forms do need to be signed by a broker in charge, or you need to have something in writing showing that you could sign it on your broker in charge's behalf. If you do not have one of those two things, when the commission knocks on your door, there's going to be issues. So like I said, this forms change was made in line with some recent real estate commission cases. Companion changes were made on the conditional release from buyer agency agreement. Again, the same disclaimer at the top that this should be signed by the broker in charge, only can be signed by the associated licensee with written authorization from the broker in charge. Change the definition, or change broker to brokerage throughout. Again, the expenses are payable to the brokerage. And again, it's signed by the broker in charge, not by the associated licensee. So those are the changes to 250 and 255. The next changes to Form 300 and 310. We're going to just be showing you 310 today, but it's the exact same change that is being made into Form 300. So it's identical. So whether you use the condo contract or the residential contract, these same changes are going to occur there. So these changes, the first one occurs in paragraph 6. That is transaction cost. So currently in transaction costs, we have 3 sections. We have 3 paragraphs. We have a paragraph that discusses what the buyer costs are, what the seller costs are. We have a middle paragraph where we talk about some options for splitting up certain costs, whether it's a buyer cost or seller cost. And then the last paragraph is where we talk about whether or not the seller is going to pay any of the buyer's transaction cost. So what the committee did here is they kind of broke up that section a little bit to try to make it a little easier for consumers to read, members to explain. It's not so bulky. So the first, this A right here, 1 and 2, that is what was previously that first paragraph. We just broke out buyer cost to one paragraph on its own and seller cost to one paragraph on its own. So a lot easier to say, hey, buyer, you're responsible for everything in number 1. Seller, you're responsible for everything in number 2. Where you see number 3 here, that is what was previously that second paragraph. So we have in here the following cost, or in addition to those considered above. So in addition to the buyer cost in 1 or the seller cost in 2, will be considered buyer or seller cost. And just like on the current version of the form, if that box is not checked, it will automatically be a seller cost. So what are those costs? A, any cost to obtain information from or pertaining to an owners association. So there's been a lot of calls on the hotline of what exactly does that mean? So the committee said, let's put some examples in there. This mostly applies to if the HOA has, hey, we'll give you a copy of the code of our covenants. We'll give you our budget, but if you want a printed copy or if you want us to send you a copy, there's a document or printing fee associated with that. So A would be any of those sort of fees. B is any public or private transfer fee. If there's a transfer fee associated with a neighborhood, HOA, or if you're in the municipality that has the public transfer fee, B would be where that would apply. And then C would be any cost similar to a transfer fee, such as certificate assessment, capital contribution, working capital, estoppel fees, or any other similar fees. Yeah, so essentially, if there's a fee that's associated with transferring the property, if you're only being assessed this fee because the property is transferring hands, that would apply under that third option there. And then 4 is what we have as that last, currently is our third paragraph. So how much of the buyer's transaction cost is the seller going to pay at closing? That's a negotiable term. The parties can try to figure that out. So one thing I'll explain here is, let's say, and I get this one all the time, because we now have to put a private transfer fee, has to be a buyer cost or a seller cost. Well, what if the parties want to split it? So say it's a $30,000 private transfer fee. The neighborhood says, hey, once you join here, we have a $30,000 transfer fee. Buyer and seller think we should be able to split that. So what will we do? We would mark this as a buyer's transaction cost in paragraph 3. And then in paragraph 4, we would say that the seller will pay the buyer's transaction cost not to exceed $15,000. That's going to allow the seller to pay $15,000 of buyer's transaction cost, which will now include the $30,000 transfer fee. So it does not require you to draft any new verbiage. It doesn't require you to draft an addendum saying they're going to split it. You don't have to create a third checkbox. Just do take whatever the math is, make it a buyer cost, and then put half of it, 40%, 60%, whatever the parties agree to split in paragraph 4. So now the highlighted stuff is stuff that we're adding. Have in there that HOA dues and assessments are not considered transaction costs and are addressed by the closing attorney per paragraph 22. So when we talk about transfer fees, we're not talking about HOA dues. A transfer fee, again, is a non-recurring fee that is being assessed solely because a transfer in property ownership. If this fee would have existed, whether or not the property is being transferred, then it's not a transfer fee or a cost similar to a transfer fee. Paragraph 3 is really addressing those costs that are solely being charged because the property is changing hands. But we are now adding into paragraph 6, HOA assessments. So this was previously covered somewhat in paragraph 22 of the contract. It is now being moved up, and there's now going to be 2 options based on some changes we're seeing in the market. The first option is what is currently available in our contract. Any special assessment approved prior to closing is the responsibility of the seller. Any special assessment approved after closing is responsibility of the buyer. Any remainder on a balance due on a special assessment approved prior to closing will be paid by the seller at closing. So essentially, whoever is owning the property at the time is going to be responsible for the special assessment, because presumably they voted for it. They voted for the board who put it in place. They have the most knowledge about it. So that's your first option. That is currently what we have here. Again, this does not apply to HOA dues, membership fees. This is actual assessments, special assessments, non-recurring, unexpected, etc. So option 2 is where it's a little different. The next one is if the seller is going to be responsible for any portion of the special assessment approved prior to closing that is due within the calendar year of closing. Any remaining special assessment payments in subsequent years are the responsibility of the buyer, and we direct the closing attorney to make the appropriate adjustments, and any special assessment approved after closing is the responsibility of the buyer. So practically, how does option 2 apply? So there are a bunch of neighborhoods that will say, hey, we're going to do a capital building project. We're going to approve today on August 31st, 2023. We're going to approve a $80,000 special assessment. But we're going to tell our homeowners, you only have to pay this over a 4-year span. So essentially, we're approving $80,000 today, but it's going to be in 4 $20,000 increments. So if the seller was to put the house on the market tomorrow, the seller under option 1, the seller would be responsible for that full $80,000 because that was approved during their ownership. So the seller would be responsible for the full $80,000. Under option 2, the seller would be responsible for the $20,000 because they would be due essentially for whatever's due in the calendar year of closing. And then the buyer would be responsible for the remaining $60,000 because the buyer is the one who's in possession at the time. So depending on where you live in the state and whether there's an HOA, this could be a significant amount of money. So make sure that your client is aware of this, that they're investigating it, that you're asking your seller, if you're representing them, hey, do you guys have any special assessments looming? Do you have any out there? Let's make sure we cover this. When you're a buyer, when you're doing your due diligence, investigate what special assessments have been approved and kind of look at that there. So this is something to definitely keep in mind when having those discussions with buyers and sellers. And then the next change we made to this is paragraph 22. So we did a little bit more explanation on insurance to explain that, hey, this is where we talk about where the buyer and seller can agree to allow the closing attorney to prorate or settle this amount of money. And we had in there insurance. Obviously, we're getting a lot of calls on the hotline about what does insurance premiums, where does that fall in? So insurance indeed would say including any non-special assessments due to an increased premium. So if you're simply being assessed by your HOA an additional premium for insurance increase, that would fall under D. That would not fall under a special assessment. Now, if they call it a special insurance assessment, now we go back to paragraph 6 and that amount of money. So D would just be for any amount due to an increased premium. And we clarified in there any non-special assessments and removed the current verbiage we have in there about special assessments. So when you see stuff about insurance, really look for that word special. If it's a special assessment, we can handle that in paragraph 6. Non-special assessment, it's going to be prorated in paragraph 22. So those are the only changes that are being made to the main contract. But certainly those don't look like big changes, but they can be substantial. So make sure you're having the appropriate conversations with your buyer and seller on those. So the next change is to the notice of termination. We get a number of questions about the notice of termination form. When is it appropriate? When does the buyer have the right to terminate? When does the seller have the right to terminate? When do we use the notice of termination form? When do we use the release? So this change is really sort of geared to trying to answer those questions. So again, we have at the top that this is the notice of termination form. It cannot disperse earnest money and should not be used for that purpose. Earnest money dispersal is handled through the release form 518 because that does require both parties to agree. Again, the notice of termination is a unilateral communication. Only needs to be signed by the sender. It does not make it any more or less valid if it is not signed by the recipient. So what we've added in here is in paragraph 4 and the reasons for termination. So there's a list of ones of which are based on a contractual contingency. So these are reasons that you can terminate under the contract as it's written. Every one of these is where it says you can terminate by delivering notice form 313. So we'll kind of go over those in a little bit of order. This is also helpful if your buyer or seller is ever like, hey, can I get out of the contract? Show them this form and say, hey, you need to find, if you can't find a reason under those 7 check boxes, then we're going to have to talk to an attorney. So the first is that the buyer is terminating for due diligence reasons during the due diligence period and will provide the agreed upon termination fee with this notice. Again, the only way to terminate during due diligence or properly terminate during due diligence by delivering this form 313 and the notice of and the termination fee. The release agreement does not do it. So you need to do it for this reason. also clarifies that the termination fee is only owed during due diligence period for due diligence reasons. If you're terminating for outside the due diligence period, you will never owe the termination fee. If you're terminating for one of these other boxes and it's during the due diligence period, you will not owe the termination fee. But if you terminate outside of due diligence and you're not doing it for a contractual basis, you could be looking at breach default. So that's going to be substantially more expensive than the termination fee. So don't let a buyer think that, hey, I'll just wait until after due diligence to terminate. That's a really bad idea. The second one is the sender is terminating due to this contract being contingent on financing and the buyer's financing being denied. Under paragraph 7 of the contract, either party has the right to terminate the contract based on financing being denied. That's why that one says sender. The next one is the buyer is terminating due to this contract being contingent on appraisal and the seller's decision not to lower the purchase price of the appraised value. That's as allowed in that first checkbox in paragraph 10. Next one, the buyer is terminating this contract due to being contingent on a clear CO 100 and the seller declining to make the repairs necessary to deliver such a report. That is the option afforded to them in paragraph 11, should they have made that contingent. Next one is the sender is terminating under provisions of the buyer sale contingency in Form 504. So if you have a buyer sale contingency in Form 504, there's a number of ways in which one of the parties can terminate. So you would be terminating under that basis. Next one, seller is terminating due to the buyer's failure to deliver the earnest money by the deadline stated in the contract of sale. And then lastly, the sender is terminating due to the recipient's failure to perform some contractual obligation described below. That's going to require you to have some sort of relevant, addendum that was drafted by an attorney or something like that. But mostly it's going to be those top 6. So if the sender does not cannot reasonably and honestly check one of those first 7, they do not have a contractual basis for terminating the contract. So if they're sending a notice of termination at that point, they're doing it without a notice or contractual basis to do so. They're essentially telling the recipient, I'm planning on terminating this contract, and this notice of termination might as well be a notice of litigation form. So that's why we have option B, which says the sender is sending this notice of termination without a contractual basis to do so, and is fully aware that terminating under these conditions may result in legal claims for damages by all affected parties. This is not a valid termination. Wanted to make that nice and scary and ominous for parties so they really know that they can't just haphazardly walk out of a contract. It's a binding agreement by both parties. If you don't have the contractual basis to do so, you need to be speaking with your attorney, and as their agent, you want to advise them in writing to have done that. So those are the changes that are being made to Form 313. Hopefully that will be more helpful in explaining when and why a party can terminate from the contract, and give a little bit more explanation to the recipient of exactly why the sender is terminating. All right. So the next form is the Vacation Rental Act form. So this form was launched in March. After it was launched, a number of stakeholders, practitioners who practice in this area, reached out to staff in the Forms Committee and said, hey, I think there are a couple of tweaks that you guys could do to make this form a little bit better. To show that the Forms Committee is receptive to that stuff, that they do take your feedback seriously. There have been some tweaks made to this form to better line up with the needs of practitioners. So we still have in there the first page and a half, which is the Vacation Rental Act as listed in statute. The next is we're going to list out the vacation rental management company, or if it's being owned, if the owner themselves is doing the vacation rental management, then we're going to have their name in there. On A, the only thing that was changed was option 2. And previously it said 2 calendar days, I think, for giving the list of bookings. We're now going to give 5 days. 2 days was a little bit too quick of a turnaround. And then B and C is where there's substantial changes. So in the original version of the form, which is what we have now, there was a lot of discussion of, is the buyer going to retain the vacation rental management company? And feedback we got was, hey, buyers just went under contract, and now you're trying to ask them within a couple days to make a decision on whether or not they're going to retain this management company, who, by the way, is not a party to the contract between the buyer and the seller. And so that really wasn't, something the buyer is focused on right off the bat. It's not something the seller should be involved in. So these tweaks were kind of made. So we now have in B, and previously I think we had up to D. Now it's going to be down to A, B, and C. And B, the seller is going to notify the vacation rental management company within 14 calendar days that they have a contract for sale and provide the company the buyer's name and address. That's in line with what's required in statute. The seller is then going to provide the buyer a list of any and all fees associated with the rentals and gross receipts on those within 14 days of effective date. So same time period. And then if the buyer intends to retain this company, then all parties agree the buyer will be given the contact information, and the rental management company and the buyer can then coordinate. It's not the buyer's job to notify the seller, and they don't need to be negotiating that in this form. So kind of saying, hey, we're going to put you in touch with the right parties. We're going to provide you what's required by statute, but we're not going to make the buyer make that decision right off the bat. And then C, we have in there that seller's going to provide you all the key codes and pool passes, that type stuff. Also added in some verbiage there about what happens if there's keyless entry owned by the vacation rental management company, and providing those instructions to the buyer. And then we actually got a really a good suggestion from a member that said, hey, what do we do about furnishings? You have a vacation rental that currently says it sleeps 8 to 10. The seller plans on taking all the furniture with them, and the buyer doesn't have any furniture. What is the expectation? And so we've sort of said, hey, that the buyer agrees that they're going to provide all rentals on the same terms and conditions as agreed upon in booking. So that vacation tenant, a renter who rented a house expecting to be able to sleep 8 to 10, the buyer needs to be able to provide that. If they need to purchase the furnishings from the seller in order to do that, then we can do that through a separate bill of sale. But the expectation is going to be that the buyer gives the renter the same quality of unit that they rented. Other things besides furniture, maybe the renter really got this house because it had a grill. If there was a grill listed and that was going to be one of the amenities of the property, the buyer needs to be sure that they're providing a grill. So hopefully these are some changes that will be helpful for there. But again, it goes to show to encourage you that if there's something in one of these forms that is not working for you, or you think there's a suggestion, certainly reach out to your local member of the forms committee, reach out to staff. None of these forms are written in stone, and we're happy to try to accommodate those if possible. All right. So now we're getting to the new forms. So these are the forms that you've never seen before. These are not currently in our library, but will be live on September 12th. So the first is the sale to the associated licensee brokerage fee disclosure. So this is something that's actually required by license law. It has been in the license law since the change in January of 2017. And it's also something from case law that even dates back to the late 90s. So what this form is intended for is a scenario in which your brokerage has a listing, and one of the associated licensees within the brokerage wants to buy that listing personally, not on behalf of a client, but they want to be personally the buyer. Under statute, if that occurs, you essentially go to the seller and you have to provide them a separate written document that says, the seller, you understand that the purchaser is affiliated with our brokerage and you do not have to pay the brokerage a fee. The entire brokerage fee, meaning buyer side and listing side. So that has always been that's been a requirement since 2017 that you do that as a brokerage, that you have to have a separate written agreement. We can't write it into the contract. You can't put in the agency agreement. It's got to be a separate written agreement. So to help out with that, the form has been created. So we list out the property address, the seller, the buyer, the brokerage, acknowledge who the parties are, put in that relevant part of case law, license law. And then 3 is where you have the election. So the seller has one of two choices. Option 1 is they just waive the obligation to pay the brokerage any fee for this transaction. So they're just not going to pay you because the statute says they don't have to. And option 2 says they understand they're going to pay the fee as agreed upon their listing agreement. They acknowledge that they have the right not to, and that the buyer is affiliated with the brokerage. So here's how I would handle it if you have a buyer or a seller who selects option 1. You want to have in your brokerage office policy something that states what happens in this occurrence. And the recommendation would be to have something in your office policy that states, should we have an associated licensee who buys a property personally, they will compensate the listing broker. They will compensate the listing broker. That way, the listing broker is not harmed by you buying the property. You don't have to worry about an issue of the listing broker not acting in the client's best interest because they don't want them to accept that offer because it may cost them their compensation. So just make sure this is really focused at making sure that there's no self-dealing. All deals are as arm's length as possible. So this is going to be Form 540. This will be a form that will be used. And again, this is only to be used if the buyer is an associated licensee with the listing brokerage, meaning you're the same broker in charge. You have access to that property through like the intranet or your file cabinet. Doesn't mean that you're with the same franchise. It means you have the same broker in charge. Doesn't mean that you're representing a buyer. It means that you are personally the buyer. Okay. So the next two forms are in regards to backups. So we get a number of calls on the hotline about, hey, we're in a backup. We want to write a backup contract. We're accepting a backup contract. How do we do that? And we would refer members to Form 391, which is our clauses amendment 2 form. And there's a tiny backup clause at the bottom of the first page. That is a lot of where we refer people to Form 391. So the Forms Committee said, hey, this is so important. Why don't we make this its own standalone form? So that's what we've done. So everything that is not highlighted is exactly what is currently in the backup addendum, backup clause addendum on Form 391. So, essentially there's a deadline that this contract is contingent on all presently pending contracts being non-enforceable, no lawsuits resulting. If we're not the primary contract by this date, then this contract is null and void. Then what we have in here is that if we end up becoming the primary contract, we now are going to have a new form we'll go over in a second, Form 546, in which the seller notifies the buyer, hey, you're now in primary position. I do want to remind, though, this parties and agents, that's why we have this new part that's highlighted at the bottom, that this contract, if accepted by parties, creates a binding contract. And if either party wishes to terminate prior to the deadline above, they're going to need to consult their attorney, and any contingencies, including due diligence, begin upon the ratification of this offer. So even if you were in a backup contract, you are still in a contract. You are still in a binding contract. Your buyer can't just decide, I don't want the house anymore, I want to walk. Your due diligence starts. So if the buyer wants to terminate, they were going to probably have to pay that due diligence, that termination fee. If the seller doesn't want them anymore, the seller's going to have to talk to their attorney. So just being mindful that if you're in a backup contract, you are still under contract. So the buyer shouldn't just be going and putting offers on more properties unless they can afford both houses at the same time, because that would be potentially bad faith. So we now are going to have its own standalone form for a backup, Form 545. That way also, if you're looking for backup in your forms library, you can just type in the word backup and now a form will pop up, as opposed to before you would have to search through Form 391 to find it. And then the last new form is the one we mentioned before, the seller's notice to the buyer of elevation of primary contract. Simply, who are the parties, what's the property, and the paragraph 3. All other contracts that had priority on this property described above are null and void in those lawsuits resulting. Therefore, the buyer is now the primary contract on the subject property. And then we have the seller sign it, and the buyer acknowledges that they've received it. So this is simply the notice that the seller will provide that, hey, you're now the primary contract. No harm, no foul, we're moving forward. So those are all the changes that are going to be occurring on September 12th. If you hear of any other forms changes, you can refer individuals to this webinar and show them that, no, these are the only things that are changing. If you did notice any sort of syntax errors or anything like that throughout this webinar presentation, I can assure you that those will be reviewed. When trying to format these forms for the webinar, sometimes there's some spacing issues or series issues, but all that will be addressed. But certainly, if you have any questions after today, please do reach out to the legal hotline. Give any of our attorneys a call at 803-772-5206. Or certainly I encourage you to go ahead and just email me, austin@screaltors.org. Be happy to answer any questions you have. If you need a little bit more explanation, if you want to understand some of the rationale, when a form should be used, not be used, anything like that, I'm more than happy to assist the best we can. And again, these forms will be rolling out on Tuesday, September 12th. So I appreciate everyone's time and attention today. Hope you guys all have a great Labor Day weekend. And let's go Gamecocks and go Blue Devils. Thank you.